Okay, we covered how you got to have your copies conformed, and we covered also the fact that in some courts the clerk will stamp it and conform your copies herself. Some places like LA, they give it to you to stamp. Doesn't matter. As long as the stamp is on there, and whether the deputy clerk puts her signature on there on the stamp or not, doesn't matter. As long as the stamp is on there, that's what matters. You got proof that that paper was filed with court in case they ever lose the original, which happened to my case, one of my cases one time, and you could replace that put your conformed copy instead of original in court.
During the 10-day period, if the respondent complies with what you're asking for in the writ, do you still get the writ, or do you not get the writ from the judge?
It becomes moot. Moot means doesn't matter, irrelevant. In fact, you know what? You win. You win because the other side says about back enough. And I'm going to give you an example like that, where the clerk, you're going to see an example where the clerk wasn't transferring my paperwork to the Court of Appeals, and they couldn't because she said she couldn't find it. Oh, couldn't find it, huh? Gee, I've been looking for it for 2 weeks. I filed writ of mandate in the Superior Court. Lo and behold, she finds the papers, and she transmits them to the Superior Court. Isn't that funny? Things like that happen. So it worked. Yeah. Okay. So you give a notice of petition, and the petition you serve the other side on 10 days. You can also, that's a normal writ. You can also do emergency writs if it absolutely has to be emergency writs. Like, sorry, we like to give notices and all this stuff, but there's no time. We gotta go serve it right away. So you filed with the court immediately. Okay, and then you go and then you go serve the other side. It's kind of like an ex parte, which means one ex parte. It means one with one party. Ex means party, one party. Ex means by one party. The other party's not there. You can do that too, but I tell you, the judges really don't like to issue these ex parte kind of a stuff with a one party there, and so. Unless you got a really, really good case and you really got to have it there, while you could not wait 10 days, serve the other side like that and wait for it and all that, you can do it. But immediately as soon as you file it with the court, immediately go file it with the opposing party, respondent, and file it with the court. It's not like you got to give them a 10-day thing, but you got to file your thing right away. Immediately you got to file with the court and the other side. You file them with both immediately together, and you just ask the judge to issue it right away. Now, for example, in Orange County, you can do that, and if you want to have a writ issued emergency, you issue it you go there by 9, 10 o'clock in the morning. You pay a $20 fee for that, and then by the afternoon, by PM, they'll hear your case. But you got to have filed it at least against the other side right then and there. You better have everything right there. But they're just not likely to want to go with those things. Okay? Any other questions? Okay, well, I think what will help you understand a little bit better is by reading some of the legalese. And let's go over that. And you find out these legalese are not that difficult necessarily. Go to your cover, the first handout, which on top of it, top right, says Code of Civil Procedure. Top left says Section 1084. This is a chapter in the California Code of Civil Procedure where writs start. And in other states, you go find it in your Code of Civil Procedure or or something like that, procedural book, or it tells you about how to do it and all that. Look in there in the index of your California annotated codes or table of contents. Index is the easiest thing, of course, first. And look, and then you see the answers. So let's go in there, and I need somebody to help. Maybe Rob, could you help me see what it says? Let's read what Section 1084 is. Rob?
Designation of names of writ. The writ of mandamus may be denominated a writ of mandate.
Simple, right? It's not complicated to read this stuff. Let's go to 1085.
Courts that may issue writ. Performance compelled. It may be issued by any court, except a municipal or justice court, to an inferior tribunal, corporation, board, or person to compel the performance of an act which the law specifically enjoins as a duty resulting from an office, trust, or station, or to compel the admission of a party to the use and enjoyment of a right or office to which he is entitled and from which he is unlawfully precluded by such inferior tribunal, corporation, board, or person.
Well, that's a little bit better detail than what I told you earlier. They did a nice job. Let's go over it, okay? Let's go to the second line, okay? It's, first of all, it may be issued by any court except a municipal court to an inferior tribunal, like a municipal court, corporation, board, or person to compel the performance of an act which the law specifically enjoins, which the law specifically requires him to do, like a clerk, for example, taking your paper and filing it, right? Okay, as a duty resulting from an office, which is very often you'll run across, trust, or station, again, bureaucrat, or to compel the admission of the party to the use and enjoyment of a right. For example, you want to use a public park, and they don't let you. Okay, you don't need to do a lawsuit for that. You go to file a writ of mandate. Let me use a public park, right? You have a right to enjoy the public park, right? That would be a writ of mandate. You don't need to sue it, right? Let's suppose you're a bum. You look dirty. They want to keep the park clear of the people like you that look like a bum, right? So they stop you. You do a writ of mandate because you have a right to enjoyment of that facility. So here it continues. So to compel the admission of a party to the use and enjoyment of a right or office to which he is entitled. Someone's stopping you, for example, from going in your office. You're a government employee. And the janitor or the supervisors don't let you in. Writ of mandate. Someone else has to let you in that has a duty, and they're stopping you from going in there, right? Writ of mandate. You have a right to be there. To which he is entitled, and from which he is unlawfully precluded by such officer, inferior tribunal, corporation, board, or person. So unlawfully. Someone is stopping you. So the other side either got to have a duty to do what they're supposed to do, or you have a right to something that they are not letting you have. And you go in there and writ a mandate and have them either let you, have them do the job they're supposed to do, or let you have this thing that you have a right to. Use the public park, use the streets, or whatever that means. Or you want to look at the public record? Oh, another fun one. Go to court, look at public record. Hey, if they don't let you look at the record, you can go into court and look at anybody's file, guys. It's all public. As long as there's no court case sealing that case, y'all can do that. Y'all can go in the court tomorrow and look at my case. In fact, Brandon and I went in there and with my case, and he wanted to look at my public file, my record. They had to go get it. We waited. They couldn't find it. The stuff was missing. But yeah, and they had to. Now, if they don't let you do that, you go to Court of Appeal and force them on a writ of mandate. I had the sheriff officials didn't want to give me some of my own records when I was unlawful in jail, and they were saying, "No, we don't. We're the sheriff. We don't give nothing to nobody." I wrote to county council and I said, "Look, I'm going to give you one chance. Otherwise, I'm going to go with writ of mandate." And the county council said, "No, we'll let you have it. No problem. Go talk to your sheriff." So the threat of it, if you know it too, will make a difference.
When a tribunal or board mandates that you do something or prohibits you from doing something, and you ask them what is their authority, and they refuse to give you that authority, what is our recourse?
That's a whole different subject. It's not a subject of this class. We'll learn that. I wish I cannot cover that here, I'm afraid. Yes.
Yeah, just a question. Let's say you're not allowed into your office or something like that. You need to go ahead and file something. Since you need to get in, would that fall under the emergency? I mean, you need to do this quickly.
Yeah, sure. It depends on the circumstance. Yeah, you go in and ask for it. The worst is you got to go serve the other party anyhow, and you go file it, and you got to show that, I need it, otherwise I'm going to be harmed or something, if it's a satisfaction of a judge. If they see it, they'll issue it. Otherwise, they'll say, no, we'll wait 10 days. But it could be the next day. But it could be the next day. Could be the next day. Not likely. They don't like doing that. Okay? So right there, this is common law stuff they just codified, basically. categorized. Okay, let's skip 108 5.5 and jump down to 1086. Rob?
Issuance of writ when there is no adequate remedy at law. The writ must be issued in all cases where there is not a plain, speedy, and adequate remedy in the ordinary course of law. It must be issued upon the verified petition of the party beneficially interested.
Let's go over it slowly. Okay, the writ, first of all, must be issued in all cases where you meet the three requirements at there's no plain remedy available to you in the ordinary course of law, there's no adequate remedy available to you in the ordinary course of law, and a speedy remedy available to you in the course of law. That's what they're telling you in there, right? It's all right there. Okay, 2 questions. 1, 2.
Are they trying to remove the discretion of the judge? Is that why they've written it like that?
Well, they're written it like that because you have a right to it. I mean, yeah, they got to issue it. I mean, the court's got to act. They put it in there so the courts don't play games with you, and you can't go to a higher court of appeal that decision, and fix that thing. Yeah.
Okay, it said it must be issued upon the verified petition.
Let's talk about that. Okay. What that means is, in your petition, by the way, you got to allege some facts, don't you? You got to claim, state some facts, right? Well, you got to prove your case. So you cannot just say something, hey, this and that happened. You got to say whatever you say and have it be verified under oath. Yourself or your friend or witnesses, whoever. It's got to be somebody under oath stating the facts. And that's what they're saying. You got to have a verified statement of somebody as a basis of the facts of your writ, your petition.
I just want a little clarification. Now, we as the petitioners are the ones that are going to do the petition, and the judge is actually the one that writes and issues the writ.
Well, what you do is that typically what you do is you file a petition, right? You also include in there a copy of your writ that you want him to issue, and he'll either a form with all the blanks in there so you can fill in the blank for the judge, because the judges are lazy. They like to make it easy for them, and you want him to issue your thing, make it easy for them. But he doesn't have to give you the writ if he doesn't want to, and he doesn't have to use your form if he doesn't want to. He can do his own if he wants to. But you make it easy for them by putting the writ, which is like an order, in there for him to issue. Okay? You tell me the answer you want. Say, here it is. Make it. What's that?
So in essence, you're writing the writ for his signature.
Yeah, exactly.
You want to make it as easy as possible.
As easy as possible.
To do what you want.
To do what you want. Now, again, but remember, don't confuse the petition for the writ with the writ, okay? The petition is your request for the writ. The writ is the actual order from the judge. Okay? All right, so as we're going here, continuing on, that it must be issued upon the verified petition of the party beneficially interested. Who is beneficially interested? Who's interested in that? Person who brought it. So although you could have a oath and of other witnesses there about that stuff, you yourself who are asking for it, you got to put yourself under oath about what you're saying in there. Don't just play your games here. You got to say what happened yourself. Okay? It's very powerful, extraordinary stuff, and you got to put yourself on the line. You got to go under oath that you want the court to do something to do it. Okay? You got to make it very, put yourself on the line. Let's go to 1087.
Form of alternative or preemptory writ. The writ may be either alternative or preemptory. The alternative writ must command the party to whom it is directed immediately after the receipt of the writ at some other specified time to do the act required to be performed, or to show cause before the court at a time and place then or thereafter specified by court order why he has not done so. The preemptory writ must be in a similar form, except that the words requiring the party to show cause why he has not done as commanded must be omitted.
Okay, let's go over it slowly. The writ may either be alternative or peremptory, which I covered for you earlier. The alternative writ must command the party to whom it is directed immediately after receipt of the repeat, or at some other specified time, to do the act required to be performed. Hey, do that thing, right? Specifically do that. or to show cause before the court at a time and place then or thereafter specified by court order why he has not done so. So the alternative writ gives the other party the option to show cause, come before the court, and give explanation, show the reason, the cause, why at a certain time the court's going to specify why he hasn't done so. That's what, so you give the other party a chance to come and speak to the court and answer why they haven't done it. Well, the peremptory writ, because you're asking you're asking the court to issue it without giving the other chance to show cause, without giving the other side a time to even say I object or I have some reasons. You don't omit that part that you say, at a certain specified time that's set, to show cause. Okay? Now, in the superior court, when you file against the municipal court or against some government or body, most writs, by the way, you'll file in the superior court, in the court of general jurisdiction that hears murders and rapes type of thing. That's the general jurisdiction court. You go in the court of appeal, really only generally to do a writ against the superior court, and you go to the Supreme Court to writ against the court of appeal. So in the superior court, what was I going to say? Sorry, forgot. My mind went some other place. Okay, let's go to section 1088.
Issuance of alternative or preemptory writ, service, notice of application, default. When the application to the court is made without notice to the adverse party and the writ is allowed, the alternative must be first issued. But if the application is upon due notice and the writ is allowed, the preemptory may be issued in the first instance. With the alternative writ and also with any notice of any intention to apply for the writ, there must be served on each person against whom the writ is sought a copy of the petition. The notice of the application, when given, must be at least 10 days. The writ cannot be granted by default. The case must be heard by the court, whether the adverse party appears or not.
Okay, there's a lot right there. Let's go over it. Plain English. Okay, when the application to the court for the petition is made, right, without notice to the adverse party, right? So when you file it like emergency writ, and the writ is allowed, ex parte, the court says, okay, fine, I'll issue it peremptory, I'll give it to you. Okay, I'm sorry. If the court, if you don't give the other side a notice, the court can only issue an alternative writ. That's what it's saying. The court will not do a peremptory writ. What they're saying actually here is that if you don't give the other party notice, period. The other side got to have notice if you want to, so that they can object to it at least, sometime.
Okay, so I need to understand something. How do they get notice on an emergency writ?
On emergency writ, you go by mail. Proof of service. You send a copy to them or file it with them. That's all.
But if you're looking for an action immediately, let's say the same day in the afternoon, and then it's granted, then
that's why if you want to go, okay, then here's what you got to do. If you want action that afternoon, you go in the morning, file it against the other side, then you go file it in court, then you go ask for it. Because the other side got notice. Because even though you filed it with them that morning, they still got notice. You see what I'm saying, guys? Everybody with me?
Will they have enough time to respond?
Well, without enough time to respond. Well, that's what it says here. Let's go over this slowly here, okay? It says, when the application to the court is made without notice to the adverse party, and the writ is allowed, if they allowed, the alternative must be first issued. That means they gotta do it when they give you the chance, the side, to come and hear. They cannot just issue a peremptory. The alternative must be issued. So what are they telling you? The reverse of it is that basically, if you wanna make sure you're not stuck to the alternative, give the other side served. That's what you gotta do. And don't worry, that won't happen that often. most writs, 10 days is fine. You go in there, give the side notice, and all that. That's fine. In fact, courts of appeal, for example, they don't let you set a hearing time. The Superior Court, you can set a hearing time yourself. You go before the court, you set the time yourself.
Yes.
In a Superior Court. You pick it. Oh, yeah. I want to go to court. Isn't that wonderful? You can go and set the court. What's that?
How do you decide on how long to make the court date for, the hearing date for?
As long as it gives you the side 10 days and it fits your schedule.
Okay.
That's all you need to do. Isn't that nice?
I was sweating hairballs.
Yeah. And anything you do, what I would do is I would call the clerk and make sure you call them. And you say that sometimes if they don't do when they do writs, when they hear them, and when they don't, they might have their own nuances. That we don't do them on Tuesday afternoons, or we don't do them on Thursday mornings. Okay, you don't set it for that time. Okay, and to get the telephone number of the clerks, call them up. Get any kind of an inside court number. If in the big cities like LA and Orange County, it's hard to get those numbers. In small towns, you can get the number of clerks easy, but California lawyers, for example, have a directory of attorneys that's printed, and they have the numbers, all courts in the state, and all this kind of interesting stuff in there. Because you won't find a telephone book, regular phone book, a lot of those things listed. Get any kind of a court number and ask an inside number, and go inside. If you don't know how to do that, call your board of supervisors of your county, and ask them to give you a number. Your representatives, they'll give it to you. That's how you get inside numbers, by the way. I once had a problem. I recently had a problem with the court erroneously wrote to DMV and my license was suspended. And I called a regular line clerk thing, and she hung up on me after I told her I'm taping it. And she wasn't really giving me a good service. So I said, fine. I went around them. Called my board of supervisors. Hey, I want to know the executive officers of the court. Right? The Robert B. Kuehl, the top guy. They gave me his number. I called him, and from there I said, I got this problem. This is being recorded. They gave me somebody that took care of me fine and nice and recorded and everything, no problem. So that's how you get inside line. Don't go through the front door, which have most of the slaves go through. Okay? And they have these telephone directories, for example, in Orange County, that they don't give to the members of the public, only to themselves. Now, one of the things one of you might want to do is to go ask for it, and then they'll give it to you, file a writ of mandate. Force them to give it to you. I'm serious. I hope one of you does this. That's one of the things I've been wanting to do, but I've been too busy. Because force the county to give it to you.
You mean the county courthouse?
The county directory, telephone number of the government. Orange County government, for example, has a directory of the inside telephone numbers of everybody. That they don't make available. They don't list it in a telephone book. In a white, yellow pages. That's our bureaucrats' numbers. They don't put it out in white pages. They only give you a few numbers for the slaves to call, and you get these voicemails, long waits, right?
Internal phone book.
Internal phone book, but it's not. They shouldn't be. It's not secrecy. It's open government, right? It's a public record, right? You have a right to that public record. Go get it.
It's ours.
It's ours. But somebody going to follow writ, get issued. Once one of you gets it, guess what? When you get the copy of your writ, hand it out to everybody, you go in there to say with a copy of that writ, okay, you're going to give me one, or I'm going to do the same thing like here. The court says you got to give it to me. And once we get it, we'll open it up, they know, yeah, we got to give it. The court said we got to give it to everybody. That's it. In your county, you taught them a lesson. They're not going to do that wrong because they know. And it's not hard. I hope by the end of the class you'll see how you guys can do one. Hold on. What's that?
Then who would we approach to get that directory?
That's a good question. I would call the I really again I didn't have the time. I didn't research it, but I would call the board of supervisors. Any of them will do. Call them and ask them where can I get that. Ask them who publishes that, and whose office that issues it. They say, I don't know, maybe it's a county printer, I assume. I don't know, but just ask them. They'll tell you, well, yeah, this office and so issues it. What's their address? Where are they? I would go in person to that office with my tape. Well, you don't have to tape it, actually, but it's nice to go with a tape, too. find out who's the guy that actually, issues those things to the county people, and say, okay, I want this thing, and I'm recording it for you to know. I want to copy this thing. We can't give it to you. Well, I'm giving you notice, by the way, for writ purposes, that this is notice to you. I'm asking you for this directory. If you don't give it to me, I'm going to file a petition, writ of mandate in the superior court, in the criminal court, or having you ordered to show cause. Why aren't you letting me have this thing? That's public record. And right there, he might back off. Or once you file a petition,
Would they sell it to you, or
I would ask them. That's one of the things I ask them. By the way, is this for sale? How much it is? See, they don't sell it to you because they give it to you. It's for their own use. They give it to everybody. So I would ask them first, how much is the charge for it? They say probably going to tell you, oh, there's no charge, but it's only available to the bureaucracy. Then guess what? They just nailed themselves with no charge. So when you get it, you don't have to pay for it. I would get around, and that's set them up for that. That's an extra benefit you could do.
When he or she, court clerk, refuses to give you something, is the writ of mandate against that person? Do you need a name or no?
Yes. Glad you asked. That was a good question I was going to get to. You ask for the writ against a particular person.
they won't give you the name?
Okay? And hold on. You cannot go and say against the municipal court judge or the presiding judge or the controller of the state. You got to go Judge Jim Jones, Judge, Edward Laird, Judge Richard Stanford. Okay, you got to name that person because there is somebody in charge. Okay, and if they don't give it to you, well, you see, there's somebody who's not giving it to you. For example, you got to put this scenario in there. How would it be who doesn't give a name? You've obviously gone to somebody who didn't give it to you, right? If the clerk did not let you go see the judge, see who that clerk is, you're going to get writ against that clerk first. And you know that clerk's name. If they don't give it to you, put it in there. Put the description of the person as best as you can. Against the supervisor of the municipal court, traffic ticket, this height and weight, who refused to identify himself but appeared to be in charge and and refused to let me look at the records, for example. Describe him as best as you can. Height, weight, looks, ethnicity, long hair, short hair, color, eyes, everything, time and date. Put it all in there. That's all you can do. So you got to be as specific as you can.
Answers to the name God.
Huh?
Answers to the name God.
I tell you something. This is interesting. There was this guru, a sovereign state citizenship guru in LA area, that everybody thought he really knew his stuff. And when I found out he really didn't know his stuff, I found out he really doesn't know it. Because he claimed that, you can go rescind your plates and everything in your car and go drive free without a driver's license and so forth, all these things. I don't want to name him on the tape. Okay, you're right. And we were at a meeting, and he was claiming, really knows stuff. He was sharing new stuff. New stuff, the stuff he found out recently, he read in court cases. And at this meeting with the top people, he said that when you get a writ, I read this court case, you got to get it against the person who you're seeking it. And I thought, you just found that out? You just found this out. Jeez, I know there's some, I'm the guy under him, and I found it. So I'm thinking, how about all these other, you must have done writs before for all these people you got around you. I mean, the guy had over 150 people show up to his meetings every month. He had a bunch of lieutenants under him that did this stuff, that helped others, that he supposedly helped out, and he didn't even know how to do a writ himself. I'm sure all the writs he'd done were denied, at least for that reason alone by itself, because he never named the person who was sought against. Yeah. The other thing I got to tell you about writs is that real party and interest. A real party and interest is who is the real party who you're seeking, who has an interest in here. Generally speaking, that is the state. Okay? When you go, because you're going against the government agency, right? The real party interest is the state of California, because who does that judge represent? Who does the franchise tax board office then represent? Who does that clerk of the court or that government official represent? The state, the government. They are the real people you're really after. That agent you're trying to have them perform their job is merely that, an agent. The real party interest is the state. So you find most often real party in interest, is the state of California, or whatever your state might be, or the United States. Okay. So let's get your question on tape.
On writ, is that public record too that you filed that against somebody? In other words, that will always be able to be noticed that you had filed, somebody had a writ against them?
Sure, it's all public. Remember, all court stuff is public. Okay, you guys want to take a break at this time? Yeah. Sure. Okay. Let's take a break and and then we'll continue afterwards. Okay. So let's go over 1088 as we continue as as we're saying. Okay. So we go on the second line. We're going to continue on 1088 second line. It says, but if the application, that's petition for the writ they're talking about, is upon due notice, that means you gave the other party notice, and the writ is allowed, and if they gave you the writ, the peremptory may be issued in the first instance. So if you want a peremptory writ issued on the first instance, when the court sees it, you gotta give the other party notice. That's the key part. He goes on. With the alternative writ, and also with any notice of an intention to apply for a writ, there must be served on each person against whom the writ is sought a copy of the petition. So you got to give the other side a copy of the petition. Well, what are you asking for in detail? And you got to give them a notice of petition, and you got to serve them the petition so they know what it is that you're coming after with them, right? Yes.
This means that if I was doing this against the clerk, then I would have to give her or him personally served a copy of this thing.
Oh yeah, absolutely, yeah. The notice of the application, when given, the application for writ, when you give that, must be at least 10 days. Okay? The writ cannot be granted by default. The case must be heard by the court whether the adverse